afternoon, Judge May.
Good afternoon.
And welcome.
Thank you.
I'd like to give you the opportunity to get settled, and when you are ready, you may begin with your opening statement.
Thank you very much. Chairperson Roberts, Secretary Law, Commissioners, I want to thank you for your service. I want to thank you for this opportunity to meet with you once again. When I saw that I was going to be the last interview of the day, I had a little trepidation, but I thought to myself, also, this is my chance to give a closing argument, and I hope you'll indulge me as I pursue that theme a little bit. Closing arguments in a trial are an exciting time, especially for the jury, because they've listened to all the evidence, they've got the instructions, and the only thing between them and deliberations, and maybe even a lunch sometimes, is that closing argument where the lawyer will bring it together, the lawyers will bring it together and show them why the verdict should go one way or another. And I feel like that, in a sense, we are at that stage because you've had a lot of evidence about me through my application and otherwise. You know what the instructions are. You know that you're seeking the most qualified candidates. And so it's just left to me to really tell you in my words why I think that I am among the most qualified applicants. I want to focus on three qualifications, three parts of my history. And if you'll indulge me further, I love imagery and closing arguments, so I would think of these as maybe three stories of a building. And number one is my experience as an attorney, as a litigator. And then number two, my experience as a district court judge. And then number three, as a court of appeals judge. So starting out sort of with that first floor, the foundation, is my experience as a litigator. And for many attorneys, including me, litigating in the courts is how we learn how the courts work. And it's how, by representing clients, we come to understand just exactly how the decisions of the courts impact our clients. And by our clients, I'm talking about the people and businesses in Iowa, Iowans. So for me, I've had 17 years of litigation experience. I've worked in a small firm. I've worked in a large firm. I've had clients, all sorts of individuals, farmers and pharmacists and a prisoner and teenagers. I've also represented businesses of all sorts of sizes. I've represented them in state district court and federal district court and bankruptcy court and argued before the Iowa Court of Appeals and the Iowa Supreme Court and the Eighth Circuit, won some and lost some. In short, I have that background of having been the lawyer who understands how the court's decisions impact clients, meaning the people of Iowa. And I think that's an important foundation for any judge, particularly those on the Supreme Court. So that's my first floor, or sort of the foundation. I move on to the second floor, and that's my time as a district court judge. And, almost all appeals, whether they go to the Court of Appeals or whether they come to the Supreme Court, they are all based on the same premise, that the district court judge messed up. That's the central premise. The appellant is trying to say the district court judge messed up. So if you're going to be an appellate judge, either at the Court of Appeals or at the Supreme Court, you are a judge of judges. And if you're going to be a judge of judges, it helps to have been a judge yourself and have that boots-on-the-ground experience of actually doing it. And I have that through my experience at Polk County, scores of trials and hundreds of other hearings. And I think that it's particularly important to have that practical experience when you realize that the Supreme Court, while they're dealing with important issues of law and constitutional principles, they are often also dealing with specific procedures that we undertake at the district court level. Decisions in the last few years about how to do, the circumstances surrounding guilty pleas or sentencing, particularly with juvenile offenders or jury selection. These issues, while they are based on constitutional arguments, are saturated with practical implications, and the experience of actually being a district judge who has performed those procedures is invaluable for an appellate judge. So that brings me to the third layer or floor, and that's the Court of Appeals experience that I've got. And during my time there, I have written dozens of opinions and voted on dozens more, and that brings a lot, in my view, to my background. But the one thing that I would emphasize, as I did the last time we talked, is that it shows you a record. It shows you how I behave as an appellate judge for the state of Iowa. And the record, I don't claim that any of my record in life has been perfect, but what I would say about my record is, if you look at the cases I've decided, I consistently do my best to apply the law as it's written to the facts and come to the right decision wherever the chips will fall. And that is what you want from a judge at any level, and that is what you certainly want from an Iowa Supreme Court justice. And so, given this background of being an attorney, being a district court judge, being a serving Court of Appeals judge, I recommend myself to you as qualified to serve on the Supreme Court from day one, as someone who's ready to take up those obligations, and I welcome your questions.
Thank you, Judge May. And so we will begin our question time with Mr. Sukup.
Thank you. Justice May, what was your biggest observation or surprise in moving from the district court to the appeals court in the last few years?
Right. I think one observation, and as I just said, is just how often I find myself calling on my experience as a district judge. When you're doing appellate work, you hear a lot of arguments about, well, the district judge should have done A, B, and C. And if you've actually sat in the chair of a district judge and done that work, there are voices in your head that say, well, wait, if they'd done A, B, and C, then D, E, and F would have happened, and that would have messed up T, H, I. So the consequences and what's practical and what's possible for the district judge, the ongoing importance of that for me as a contributor to the appellate courts, that has been a sort of an almost daily sense.
Thank you.
Thank you.
Ms. Valentine.
Thank you. Good afternoon, Judge.
Thank you. Good afternoon.
I'm curious what you believe the role of precedent is in our judicial system, and how you look at precedent in terms of your decision making on the bench.
If we look at precedent, and the lawyers might say stare decisis, right? The idea that prior decisions are binding on the current decision, it depends on the context. For example, if a constitutional decision is clearly wrong, then it's our constitutional obligation to change, to go in a different direction. And that would be a Supreme Court role, of course. In my role as a district court judge and as a Court of Appeals judge, we're continuously bound by the Supreme Court's rulings, and so that's been my experience in following those. But again, precedent's going to mean different things in different situations. And if we're talking about common law rules that have been established for hundreds, sometimes 1,000 years, I would expect that those are well established and that we would continue on with those. But it depends on the setting. And I guess I'll say in any situation, I'm always open to persuasion of counsel in any argument.
Thank you.
Thank you.
Mrs. Sinclair.
No questions.
Ms. Conover.
Judge, I've asked a few applicants a question along these lines, and your application is somewhat unique because you come with a private practice background, district court background, and now appellate court background. But moving to the Supreme Court, the role is a little bit different in that the Supreme Court hears issues of first impression, is sometimes resolving unsettled areas of the law that perhaps the Court of Appeals doesn't encounter. And I hear some lawyers complain that we have too many dissents coming out of the Supreme Court, that we should have a more unified Supreme Court. And I'm just curious your philosophy as you look ahead to the Supreme Court. If you are appointed, do you think building consensus and coming up with a unanimous opinion should be the goal? Are dissents okay? If there's a robust discussion about the issues and folks just can't agree, have you given any thought to those issues?
Yeah, absolutely. And I would say two or three things. One is that issues of first impression, well, they're finally decided by the Supreme Court. Of course, they start in the district court, and I had to run into a few of those down at Polk County, so it's not the same as being on an appeals court, although even the Court of Appeals occasionally runs into one. And if you look at my Fischel versus Redenbaugh decision, that's a first impression case, so that'd be an example. What I would say is this. The Supreme Court, like any appellate court, has to mix two things together, and that is collegiality and independence. And I've talked about these before. I want all 7 justices of our Supreme Court to bring their independent points of view to every case. And as you say, robust discussion must be the norm. Sometimes things just fall into place, and it's obvious what the answer should be. And sometimes not, though. And sometimes there's room for a dissent or a special concurrence, whatever it might be. Pardon me if I'm getting lost in the layers. But what I would say is, my practice on the Court of Appeals is when we have a case that comes forward, is it better if we all come to the best decision, if all 3 minds talk it through and say, here's the answer? Yeah, that is an ideal situation. But by all means, if there is, I want everyone to vote their conscience, and I vote my conscience. And I have written a few special concurrences and dissents in my role as a Court of Appeals judge, and I don't think there's anything wrong with that. I think it's part of how the law develops. But I also think that when there is dissent, when there is division of opinion, we need to work through that on the case, and then we need to move on together as a collegial court, as a team that's working for the best of Iowa, and not make it turn into a personal issue.
Thank you.
Thank you.
Mr. Berger.
No question.
Mr. Goodman.
Judge May, thank you for your application. This commission has been asked from time to time to consider geography, and in fact, we've considered geography in the past. And what I'd like to know is, I could probably look at the application and find out where you live, but where do you live now? Where'd you grow up? And where'd you live in between?
Sure. Thank you. So my life is divisible into 3 chunks, I would say. I grew up and spent the first 18 years of my life, and 19 total, in the town of Kirksville, Missouri. It's a town of about 17,000. We lived out on the edge of town, and so that's one chunk of my life. And then there's the middle chunk where I was going to school, and I lived in Des Moines, and I lived in Tulsa for a while, and lived in Urbandale for a little bit, and I lived in Columbia, Missouri, as I pursued undergrad and a graduate degree in law school and getting started with my life. And then my wife Paula and I, we've been married for 23 years. As we were deciding where to raise a family, we looked around and we found Polk City. It's a town of about 4,600, and with the North Polk School District. And so we've lived out there for the last about 17 years. So let's say 35 of my years have been spent in relatively rural areas, and then the remaining, sorry with the math, 12 or 13 years were sort of the middle period where I was in more urban areas.
Thank you.
Thank you. Mr. Bloom.
No questions.
Mr. Bevel.
No questions.
Ms. Law.
No questions, thank you.
Mr. Spies.
Judge May, I'm really intrigued by your notion of being a judge of judges, and I know that so many of the cases that you and the court decide, involve whether a judge has abused discretion. And for those of us who regularly claim that judges abuse discretion, we often see this as a safe haven for judges, and that maybe you as a judge, having exercised discretion, seen it, felt it, exercised it, are more sympathetic to the mistakes that we think judges make. Could you address that for me?
Well, There are 1,700 employees in the judicial branch, and a very few of them are here in this building. And most of the judges are actually out in the other 99 counties. I think there are 100 courthouses. And the law does sometimes allow discretion. It uses the word may to indicate discretion, and that is what our legislature has intended in a variety of circumstances. And the judge who is on the scene is often in the best position to see and hear what is actually happening, whether it's an evidence objection in the middle of trial, whether it's a decision about sentencing. That idea of having some discretion that the district judge has to exercise, I think, is an important part of our system. It's how our system can function, because we just cannot correct all of those things on the appellate level, nor would we be good at it just looking at cold transcripts. So we do vest a lot of importance on the district judge. That said, there are abuses of discretion. District judges do make mistakes. I'm sure I made mistakes. So I know at firsthand that it can happen, and we're here to correct those when they're shown to us.
Thanks.
Mr. Horbach.
Thank you, Madam Chair. This is my last commission meeting, and I know I've finally made it big because the Honorable Mr. Spies took my question. I've finally come to that point in my life. I want to thank you for applying. I have no questions.
Thank you for your service.
Ms. O'Brien.
No questions, thanks.
Mr. Hoytick.
Judge, thank you. No questions. Thank you for applying.
And Mr. Gray.
No questions, thank you.
Ms. Pearson.
No questions.
Ms. Stanger.
I see it's yellow, so.
It is yellow, but we've got time for a question. We have time for a question, yes.
Well, my dad would tell you I'd never miss an opportunity to speak in second grade. My husband probably said that too. Anyway, Judge May, you described your 3 tiers, parts of your building, floors of your building. Looking back at all of those experiences, is there a particular case or matter that came before you or that you worked on that has made an impact on you and might shape the way you would approach cases at the Supreme Court level?
Thank you for the question. Countless, I would say. If you don't mind, I'm going to change the question just a little bit and talk about the administrative role of the Supreme Court, though, because I was a drug court judge down at Polk County, and one of the things that is on the table in this building and being talked about is the role of problem-solving courts in our state. And let me just try to say quickly what I think about that. On a regular basis, as a felony drug judge in 2017, I probably sentenced 200 people on felony drug cases. I saw them once or twice. I had a decision between prison and probation or prison and more prison, and we did the best we could to address their problems under the circumstances, but I think everybody left that courtroom probably thinking we didn't make transformational change. And that's a limitation of our system. If you look at 2018, when I got to be the drug court judge, now this is a special remedial program. There are only 30 defendants in it. They come to court every week and get to see the judge. And the judge asked them, the first thing I got to ask them was how your week went. And they have an intensive program of things they have to go through. They have to keep a job, sometimes for the first time in decades, to keep a job throughout this entire program. They go through treatment. They go through counseling. They get on the medication that they need. They check in with DOC people, Department of Corrections people, twice a week or more. They come to, like I say, they come to court each week, clean clothes, collared shirts, etc. Many drop out. Many are not ready for this intensive level of treatment. But I must say that when you've been with someone every week or every other week for a year and a half, 2 years, and you're able to see actual transformation, true transformation of a person. A person who's proud to be having a job, paying taxes, living their life right, reuniting with family members. It's an extraordinarily moving thing. And I will carry my advocacy for our drug court programs forward. We always have to find out what works and what doesn't work. There are scarce resources. I understand all that. But the experiment that we've started with those drug court programs, I believe, is a clue that we should continue to explore and that the branch is exploring through its investment in problem-solving courts.
Thank you. Great. Well, thank you. Thank you, Judge May, for being here today and taking our questions and spending time with us. We wish you well.
Thank you all.